Arthur Hall v. Simons, 2000. This case involved 3 conjoined appeals concerning claims against solicitors. Each solicitor had relied on the immunity rule relating to advocacy in negligence claims. At first instance, the trial judge had struck out each claim. The Court of Appeal held that the claims were wrongly struck out. The House of Lords was invited to reconsider the immunity of legal professionals when conducting advocacy in court. The rule relating to immunity of an advocate in respect of and relating to conduct of legal proceedings should no longer be maintained. Lord Stein, there would be benefits to be gained from the ending of immunity. First, and most importantly, it will bring to an end an anomalous exception to the basic premise that there should be a remedy for a wrong. There is no reason to fear a flood of negligence suits against barristers. The mere doing of his duty to the court by the advocate to the detriment of his client could never be called negligent. Indeed, if the advocate's conduct was bona fide dictated by his perception of his duty to the court, there would be no possibility of the court holding him to be negligent. Moreover, when such claims are made, courts will take into account the difficult decisions faced daily by barristers working in demanding situations to tight timetables. For broadly similar reasons, it will not be easy to establish negligence against a barrister. The courts can be trusted to differentiate between errors of judgment and true negligence. In any event, a plaintiff who claims that poor advocacy resulted in an unfavorable outcome will face the very great obstacle of showing that a better standard of advocacy would have resulted in a more favorable outcome. Unmeritorious claims against barristers will be struck out. The new Civil Procedure Rules, 1999, have made it easier to dispose summarily of such claims, Rules 3, 4, 2a, and 24.2. The only argument that remains is that the fear of unfounded actions might have a negative effect on the conduct of advocates. This is a most flimsy foundation, unsupported by empirical evidence, for the immunity. Secondly, it must be borne in mind that one of the functions of tort law is to set external standards of behavior for the benefit of the public. And it would be right to say that while standards at the bar are generally high, in some respects there is room for improvement. An exposure of isolated acts of incompetence at the bar will strengthen rather than weaken the legal system. Thirdly, and most importantly, public confidence in the legal system is not enhanced by the existence of the immunity. The appearance is created that the law singles out its own for protection, no matter how flagrant the breach of the barrister. The world has changed since 1967. The practice of law has become more commercialized. Barristers may now advertise. They may now enter into contracts for legal services with their professional clients. They are now obliged to carry insurance. On the other hand, today we live in a consumerist society in which people have a much greater awareness of their rights. If they have suffered a wrong as a result of the provision of negligent professional services, they expect to have the right to claim redress. It tends to erode confidence in the legal system if advocates, alone among professional men, are immune from liability for negligence.